We're going to go over prenuptial agreements in Alabama. My name is Sam Bone. I'm an Alabama divorce lawyer. So what is a prenup? A prenup is an agreement made before marriage to resolve issues of support and property division if the marriage ends in divorce or by death of spouse. There's also a postnup. So a prenup is something that you and your spouse draw up before you get married, and a postnup is something you will do after you get married. So you might get 3 or 4 years into the marriage, and then at that point you guys decide how you want to divide up property and things like that, but you still want to remain married. It's just essentially the same thing in as a prenup. It's just you did it afterwards. And in Alabama, the law for prenups and postnups are essentially the same and go by the same standards. So in Alabama, are prenups and postnups valid? Absolutely. They are valid in Alabama, and here's the law. However, courts will scrutinize these agreements to determine whether they are just and reasonable. So reasons why you want a prenup. I'm going to give a lot of this lady here, Lawyer Kelly, on TikTok, for you to see reasons I believe or anyone would want a prenup. Number one is that Alabama state law is the default prenup. You already have a prenup, whether you know it or not. The state law is your prenup. So do you want the government before your marriage to dictate what you guys do divorce, or do you and your spouse or fiance at that time want to dictate that beforehand?
Did you know that when you get married, everybody has a prenup? Yep, the prenup is the state law that you live in. Every state has rights and obligations associated with marriage. So if you get married without drawing up your own terms and conditions, you are by default submitting to your state's prenup. Did you know that when you get married?
So let's say that you were wanting to get a prenup. How do you sell that to your fiance? Same thing. You go ahead and let them know, hey, you've already got a prenup, and it's the state law, Alabama state law. Again, just because you're the poor spouse does not mean it can't protect you. The poor spouse can dictate with things that protect them in the prenup as well. It can say, hey, you get X number of alimony, or you get X number of property settlement out of the estate per year. I mean, you also, as the poor spouse, have some power here.
How do I suggest a prenup to my fiance? Let them know they already have a prenup. It's called state law. Marriage is a legal contract, and every state has laws that apply to you when you get married. If you own a house or a business before marriage, these laws may not be good for you. At the very least, you should talk to an attorney before you get married to see if you need a prenup or not. How do I suggest a
So reasons to get a prenup would be preservation of separate property, that you had money or business beforehand, protection against debts incurred if your spouse is running up credit cards, limitation and or protection with alimony. You can't waive child support, but you can waive alimony or set alimony beforehand, so that if you're the poorer spouse, for instance, that you're protected in the event of a divorce. So here in Alabama, we have one case that I call the granddaddy of prenups here in Alabama. It's called Barnhill versus Barnhill. It's created an either-or test, so it's a two-pronged test. You can satisfy either one. The first, so you don't have to satisfy both. In order for it to be valid, and the burden is on you who's trying to enforce the prenup, you've got to hit one of these two. Number one, the consideration was adequate, and that the entire transaction was fair, just, and equitable from the other party's point of view, or that the agreement was freely and voluntarily entered into with competent, independent advice and full knowledge of any interest in the state and its proximate value. So let's go into number one, that first prong. This one does not require the other party to have a lawyer. And when you don't have a lawyer, the other party has to have a general knowledge of the other party's estate. And you can't void the agreement simply because there's a substantial difference in rights between the parties. However, it, it has to be fair, just, and equitable if the other party is not going to have a lawyer. So the main difference is fair, just, and equitable. If the other party doesn't have a lawyer, they have a lawyer, it has to be fair. It doesn't have to be fair, just, and equitable necessarily. In first prong, if they don't have a lawyer, you have to they have to have a general knowledge. The other one, if they have a lawyer, it has to be an exact, not, and include values. So, can a court set aside a prenup because of disparity of net worth? Disparity between each party's net worth is not a consideration when determining whether a prenuptial postnuptial agreement is fair and equitable. Typically, the whole reason parties enter into a prenup is because they have vastly different incomes and assets that they wish to protect in the case of divorce or death. The very impetus behind the creation of such agreements should not be a reason to set them aside as inequitable. So the second prong, freely and voluntarily entered into with competent independent advice and full knowledge of any interest in the estate and its approximate value. So the agreement does not have to be fair, but the other side must have an attorney, must have full knowledge of any interest in the estate and its approximate value. So when we're drawing up the prenup, we've got to list out the assets, debts, and an approximate value for each of those. So what are some ways to challenge a prenup? You can say that there's a lack of full disclosure. They didn't tell you about that debt, or they didn't tell you they owned that piece of property, or they told you they owned a business, but you didn't know the business was worth that much. Number two would be lack of consideration. We've got two cases here, Harrison, mayor versus mayor, where you can get those set aside. This is more for lawyers there. Signed under fraud or duress. Let's say that you had all your family in town for the wedding and your spouse gives you the prenup right before you walk down the aisle. That would be duress. And number four is not fair or just. It's completely an unfair prenup, and you didn't have a lawyer. Sunset clauses. Sunset clause is a provision in your prenup that says after a set amount of time, your prenup will automatically expire. This video, we're going to go over some problems with that.
If you ever get a prenup, don't get a sunset clause. A sunset clause is a provision in your prenup that says after a set amount of time, your prenup will automatically expire. So why not? First, remember why you got a prenup: to protect against a divorce. If you stay married, it never gets used, so why let it expire? Number two, I can get promotes divorce. If you knew your prenup expires in 10 years, you would file for divorce at year 9. And number three, once your prenup expires, the law takes over. The law may not be good for you. Chris Rock allegedly had a sunset clause that voided his. If you ever get a prenup, don't get a sunset clause. A sunset clause is a provision in your prenup that says